Hello everyone, welcome to the new series of Drishti IAS. I am Ritu and today we are going to discuss very important topic of GS2, which is polity, which is about governors' powers and how many times they are crossing the lines. So in the recent past we have seen that governors are crossing their line. So governors are usually appointed to maintain the balance between center and the state and also to maintain the federal structure of any country. But there are few incidences where we have seen that governors acted as a party workers rather than a governor of a state. So that's why we have discussed this topic and we have chosen this topic. So moving to the points of discussion part. So first of all, we are going to discuss the news and then we are going to discuss what does the constitution say about the role of governor and their assent to the bills, and can a governor in practice actually sit on a bill forever or for an indefinite time? What is the argument of the states in this case and what can the Supreme Court do in this case? And then we are going to discuss practice question for prelims and mains. So moving to the news part. So why we have chosen this topic? So recently in Tamil Nadu, what we have seen that there are more than 10 bills which are pending in nature and governor is not giving its assent to the bills. And not it is the case of just Tamil Nadu, various other state governments which are not ruled by the current ruling BJP party, they are facing such kind of the problems, just like Telangana is facing, Kerala is facing, Punjab is facing such kind of the problem. So because of that, we are discussing this topic, that what is the R.N. Ravi, who is the governor of Tamil Nadu, what he is doing and why his position has become controversial and why state government is raising objection on his position and why he is not giving assent to the various bills. So that's why we have chosen this topic. So moving to the next slide is about that what does the constitution says about the role of governors and what are the powers they have by giving or granting assent to the bills. So article 153 to 163 deals with the governors. So here what article 163 says. So article 163 says the role of governors and the power of the governor in general, and there is a specific article which is article 200 which deals with the granting power of the assent to the bill. It means that governor has right to assent to the bill. So this is the article 200. So we have various other nitty-gritties related to the article 200, and what other nitty-gritties is there, that there is a key provision, and what the key provision of article 200 says that the governor may as soon as possible return bills other than the money bills. It means that when it comes to the money bills, then governor must give its assent to the bills, because prior to the governor information, such kind of the bills introduces in the state legislative assembly and also in the parliament prior to the taking the action from the speaker and from the president of the country. But here the governor must assent to the money bill, but on the ordinary bill he has four kinds of the power. The first power is that he cannot, he can withhold his assent. The second is that he can grant his assent. The third is that he can return and reconsider for the bill. And fourth is that he can reserve the bill for the consideration of the President of the India. So these are the four powers and discretionary powers governor of any state has. And here there is a key provision which is that as soon as may be possible. So what it does? So it creates ambiguity that here no particular time limit has been defined, and that has created lots of controversy, because as soon as possible does not mean that at what kind of the possible. Different governors take it in a different way, and they have this that we are doing this thing in a very considerate way, and we are examining this bill in a very considerate way. That's why we are taking time. So there is no proper kind of consideration for such kind of the bills, and there is no cross questioning allowed that why you're not giving assent to the bills. So this is the problematic in terms of the state legislation. Moving to the next slide. So what is a tug of war? So we already have discussed that what is a tug of war. Here the time framing is a tug of war between state legislative assembly and between the governor. So when there is a bill passed both in the state legislative council and also the state legislative assembly. So few states have state legislative council and few states have just legislative assembly. So after the passing from both the houses, the bill sent to the governor, and the governor has right that he can withhold, he can grant assent, and he can reconsider, he can return also, and he can reserve also. So in that way he has four kinds of the power. But sometimes what we have seen that governors take years to grant assent to a particular kind of the bill, and sometimes they take years to return the bill, sometimes they reserve for the bill for the President of India. But there is no time limit required and time limit set for such kind of the thing. Suppose that in case of women reservation bill also we have seen that, suppose that you have designed a bill for the empowerment of the women, and there is a need of an hour that women should become part of the state legislative assembly. In order to increase their participation, we have introduced such kind of the bill. But if that bill has been not assented on the time, and if it took another 4 or 5 years to implement it, then there will be injustice towards women, because we have designed such bill for the empowerment of the women, for the empowerment of marginalized section of the society. And if the governor is taking so much time for such kind of the bills, then it is injustice to the women of that state. So in that way, this is a tug of war between governor and different state legislative assembly. Moving ahead. So next slide is about that, can a governor in practice actually sit on a bill forever? So this is a discretionary power of the governor that he can do exercise various power related to the bill. He can grant, he can withhold. So this is a kind of discretionary power, and it is also mandatory for any state legislative assembly or for any state to maintain the power between both state legislative assembly and also the center, and it also maintains the federal structure of any country. But what we can see here that there is a no indefinite time frame is decided by this. So here what word has been used at as soon as possible. It means that the governor thinks that if the bill is into the important urgency, and if it's for the upliftment of the masses, if for the welfare of the masses, then he or she must assent the bill as soon as the possible. But as soon as, the phrase as soon as possible should not taken in a different way. It means that we need to consider the urgency of any bill, and any bill should not be recommended and should not be escalated for another 3-4 years. So this is a tug of war, and governor has no right to sit on a bill and to reserve a bill for an indefinite time period. So this thing and this thin line, we should be clear about the role of governor also, that if you are given some discretionary power, that should be related to the discretion only, that should not be exploited by the office of the governor. So moving ahead. So next slide is about what are the arguments of the states in the Supreme Court. So different state government, just like Tamil Nadu, Kerala, Telangana, and even Punjab has gone to the Supreme Court regarding the role of governors, and so many important bills are pending in the Raj Bhavans, and governors are not giving the assent, and they are becoming just useless as a bill. So many state government has reached to the Supreme Court of the India. Recently Kerala government had reached to the High Court, but the High Court did not entertain such kind of the pleas, so it has reached to the Supreme Court. And what is their argument? So the Kerala government is saying that 3 bills have been pending with Governor Arif Muhammad Khan, who is the governor of the Kerala, and that bills are pending more than an year, and there is a PIL also filed in the High Court, but the High Court didn't entertain that PIL. So similarly, we can see that Telangana has also argued that more than 10 key bills which are pending in nature, which require the assent of the governor. And similarly, Tamil Nadu government has also said that there are various important issues, just like the remission orders, day-to-day files, appointment order, approving committees. So different kind of urgent bills are pending in nature and which are not approved by the Telangana or Tamil Nadu governor. So this is a very difficult situation for any state, and it is destructing the state functionaries, and it is not able to, they are not able to function administratively in a very efficient manner. Suppose that if we are introducing a bill for the welfare and for the justice of the SC/ST community, and if the governor is not granting their assent to the bill, then it must be a problem from the governor's side. It's not the problem from the state legislative assembly. And if the governor has any issues with any bill, then he can return to the bill with a proper message. And Supreme Court has also, there is a provision in Supreme Court. Supreme Court had advised the governors that you have right to give and return the bill with a proper message that you have this kind of a certain problem with this particular bill, and that bill should be read out in the state legislative assembly that why you are returning the bill, and they will consider that kind of your plea, and then after that you will give your assent to the bill. So in that way the governor should function like that, that if they have any problem with any kind of the bill, then they must send the message to the state legislative assembly. They must not withhold their assent. So moving ahead, so the next slide is about that what can the Supreme Court do now. So Supreme Court has taken various steps, and we have this famous Rebaba case. In that case, what Supreme Court had outlined that the speaker has this kind of the authority that if any governor is sending any kind of message with the bill and returning with the bill, then that message should be read aloud in the state legislative assembly, and if the state legislative assembly is not in the session, that should be informed to the every member of the state legislative assembly that governor has this kind of the issue with a particular bill. It means that they're also taking care of the opinion of the governor, and if that message and if that information is not incorporated in the what you can say particular bill, then still governor must assent their bill, because it's their duty that they cannot return again and they must assent. So if the majority and the state representative thinks that such messages should not be incorporated, then they are the legally right, because in constitution such provision is we have that they cannot incorporate, and sometimes they can incorporate. So they are not legally wrong and they are not constitutionally wrong on their part. So this is the tug of war, and this is a controversy between governors and different state legislative assembly. So we have a different kind of roles for the governor, and we have a clear-cut information and clear-cut rules for that, just as that governor has right to invite parties to form the government, and then governor has right discretionary power to advise any country, advise the president that this state needs a president rule. So these kind of the discretion we have with the governors, but we have a clear-cut information related to it. But coming to the assent of the bills, there is no clear-cut, and here word as soon as possible is creating lots of confusion. So Supreme Court must do in this regard, and Supreme Court has also said that this must and as soon as possible, the governor shall, all these phrase has been used that all these assent are mandatory in nature, and that should not be taken in an indefinite way, but still there is an ambiguity in this part and there is no clear provision in this part. So the Supreme Court must think regarding that, and different state legislative assembly and parliament also think regarding that. There should be proper time frame by giving their assent, and Supreme Court had also advised to the speaker in the case of the money bill, in the case of the disqualification of member, that you have to disqualify member on a particular date within a particular time. So just like the speaker, the governor role should be also defined by granting the bills. So this would be the role of the Supreme Court in this case, and we believe that this issue must be resolved immediately, because this is creating lots of confusion between state legislative assembly, and it is destructing our federal structure of any country. So moving ahead, the next slide is about practice question for prelims. Under which article of the Constitution can the governor refer any bill for the approval of the president? And your options are Article 166, Article 200, 239, 240. So you have to answer this in the comment section. Moving to the mains part, the mains question is, the exercise of discretionary power by any office has the moral obligation of objectivity and impartiality. However, the power bestowed in the office of the governor are often mired with the controversy analyzed. So we have seen that various state government has issue with the office of the governor. So in the intro part, what we have to do, that main question is focused on the governor. So you have to give a brief introduction of the governor, that what is the role of governor in the state, what are the constitutional provision we have related to the governor. So you have to give brief intro of the governor, and then coming to that, how his office is becoming controversial. So you can give the example of Telangana, Kerala, Tamil Nadu, Punjab, that how their offices are becoming controversial because governors are not giving their assent on the bills and they are withholding the assent on the bills, and which is creating lots of ruckus in the state legislative assembly and in the functioning of the state. So what you have to write here that, governor is appointed that, he or she should maintain the federal structure of any country and to create the balance between state and central government. So central government should not, not every day they should involve in the thick and thin politics of any state. So usually what we have seen that if any person belongs to Bihar, then any person from Bihar is not appointed as a governor of Bihar. So why the person from different state appointed as a governor? So that the person will not involve into the politics. So we have such kind of conventions in our country, but despite having a strong convention, we are thinking that all these governors, especially the governors who are ruling the opposition states, are acting as an agent of the central government and acting as a party worker. So they must know that, what are the discretion power they have, and that discretion power should not be misused. That should be used as a discretionary power, and that should be in a constitutionally limit. And we should not create much controversy between state and center. Anyway, we have lots of problems. So this should not be from the governor's side. So in that way, you can write your answer. I hope you like this lecture. If you have any query to this lecture, kindly ask in the comment section. Thank you.